Hello and welcome. You're watching NewsX with me, Devika Devan. We have some breaking news coming in the Kuldeep Sengar case. NewsX has now accessed a copy of the Supreme Court's official order on the Delhi High Court's suspension of Kuldeep Sengar's life imprisonment. In its order, the Supreme Court says that there are various substantial questions of law which now arise for consideration in the special leave petition. Remember, the Supreme Court had ordered that Kuldeep Singh Sengar shall not be released from custody pursuant to the High Court's order. Let's put this out on our screens for our viewers to see as well. As I mentioned, the Supreme Court says that there are substantial questions of law which now arise for consideration. The main part, of course, is where the Supreme Court says we are conscious of the fact that ordinarily when a convict under trial has been released on bail pursuant to an order passed by the trial court or the High Court, such order shall not be stayed by this court without hearing such person. However, the instant matter revolves around certain unique facts and circumstances wherein the respondent convict is also separately convicted and sentenced in a case under section 304 part 2 of the IPC and is consequently still in custody. We are informed that in such proceedings also the respondent convict has applied for bail, and after hearing the arguments, the order is said to have been reserved by the concerned court. Keeping these peculiar circumstances, we deem it appropriate to stay the operation of the impunged order dated 23/12/2025 passed by the High Court. Consequently, the respondent shall not be released from the custody pursuant to the said order. The victim has a statutory right to file a separate SLP. She does not require any liberty from this court. In case she needs any free legal aid, the Supreme Court Legal Services Committee is directed to provide such services to her. However, she may, if so advised, file an appeal through counsel of her own choice. That's the order, important order there, 3-page order that has been passed by the Supreme Court in the Kuldeep Sengar CBI versus Kuldeep Sengar case. And the court has now decided to put a stay on his release, because viewers remember on the 23rd of December, a major legal decision sparked a massive debate. The Delhi High Court had ordered the suspension of the sentence for Kuldeep Singh Sengar in connection with the Unnao rape case. The move came 7 years after the long and painful legal battle first began. This decision was a huge blow to the survivor. She told us on NewsX that she had lost all faith in the High Court. However, she refused to give up. She said that her faith now lies with the Supreme Court. In a powerful statement, she told us that she would even go to jail herself if that's what it took to make sure justice was served. Today, it seems the Supreme Court has heard the plea. The top court has decided to put a stay on the bail order of Kuldeep Sengar, effectively stopping Sengar's release. The judges have called the earlier decision to grant him release peculiar. For now, the convict will remain behind bars. This intervention has restored the survivor's faith in the justice system. Earlier, when she spoke to NewsX, she made her position very clear. For her, the only true justice is capital punishment. She believes that death penalty is the only way to finally close this dark chapter. The Supreme Court has stepped in, but many questions now remain. Will the courts listen to the demand for a death penalty? What is really the next step in this long journey to justice? I take this conversation forward. With me on the broadcast, Seema Kushwaha. She's an advocate of the Supreme Court and also was the advocate in the Nirbhaya case. Yogita Bhayana, who's been working with the Unnao victim, will be joining us shortly. Brinda Adige, social activist with us, and Taira Hassan, activist with us as well. Let me begin with Seema Kushwaha because it's important to understand the legalities here as well. Seema ji, I want to understand from you. Firstly, I just want to make a correction. The Supreme Court has not called the High Court order peculiar. We've made a mistake in reading that. The Supreme Court has called the circumstances peculiar rather than the order itself, because courts don't usually use such terminology for each other's judgments. But Seema ji, bringing you into the conversation, I want to understand from you, was it a very bizarre technicality that was used for Mr. Kuldeep Sengar's release? And at the same time, when we say that it depends on the courts to really interpret, where does the court draw the line, Seema ji, between interpreting an argument versus actually perhaps looking beyond and seeing the larger picture, that here is a man who has been convicted for a heinous crime and then for multiple crimes thereafter?
देखिए देविका जी, सबसे पहले तो अगर इस पूरे हम केस को समझे, दिल्ली हाई कोर्ट ने जो इनका बेल जो इनका सेंटेंस सस्पेंड किया, उसमें अभी ये बहुत छोटा सा, इसको हम कहेंगे कि पूरी तरीके से ये इस विक्टिम के फेवर में ये जजमेंट नहीं है, जस्ट स्टे किया है उसका जो सस्पेंशन है उसको, और स्टे करने के बाद इनको नोटिस इशू किया गया है। अभी इसमें एक इंटरप्रिटेशन जो कि सबसे इंपॉर्टेंट थी कि क्या कुलदीप सेंगर जो कि स्टेट की डेफिनेशन में कवर होते हैं या नहीं, ये हाई कोर्ट ने मेन इंटरप्रिटेशन की थी। क्योंकि जो पोक्सो का सेक्शन है वो कहता है कि अगर कोई स्टेट का पर्सन है, पुलिस ऑफिसर है, एमएलए, एमपी, अगर ये लोग रेप करते हैं तो जो पनिशमेंट है 7 ईयर से लेकर के 20 ईयर मैक्सिमम, वो 20 ईयर से लाइफ इम्प्रिजनमेंट तक हो सकता है। और उन्हीं सबको बेस बना करके इसमें 30,000 कोर्ट ने, सेशन कोर्ट ने इनको कन्विक्ट किया था लाइफ इम्प्रिजनमेंट ने। और जिसकी जो इंटरप्रिटेशन है दिल्ली हाई कोर्ट ने जब की, तो उन्होंने कहा कि ये स्टेट की डेफिनेशन में कवर नहीं होते हैं। आर्टिकल 12 कॉन्स्टिट्यूशन ऑफ इंडिया का स्टेट को डिफाइन करता है कि स्टेट में कौन कौन कवर होते हैं, जिसमें कि इन क्लियर कट ये मेंशन है कि स्टेट पार्लियामेंट एंड पार्लियामेंट के जो भी पार्ट है, वो सभी पर्सन जो मेंबर ऑफ पार्लियामेंट है, चाहे वो राज्यसभा सांसद हो या मेंबर ऑफ पार्लियामेंट लोकसभा सांसद हो, वैसे ही हमारी लेजिस्लेटिव असेंबली जो स्टेट में है, उसमें जो आने वाले मेंबर ऑफ लेजिस्लेटिव असेंबली हैं, वो सब, तो ये स्टेट, कुलदीप सेंगर भी उसमें कवर होते हैं। लेकिन एक सबसे बड़ी और एक बात है कि इसमें अभी तो ये मैटर और भी बहुत लंबा जाना है, क्योंकि एक अदर जो केस है जिसमें 10 इयर्स पनिशमेंट, डेथ पेनल्टी जो कि होना चाहिए था, इस बेटी के फादर का पुलिस कस्टडी में मर्डर हुआ, वो भी अभी पेंडिंग है, उसको भी डिसाइड होना है। लेकिन सबसे बड़ी बात यह है देविका जी, निर्भया केस में 7 ईयर लग गया। इस केस को सुप्रीम कोर्ट ऑफ इंडिया ने सो मोटो कॉग्निजेंस लेकर के विद इन 45 डेज में टाइम बाउंड जस्टिस की बात की थी। टाइम बाउंड फास्ट ट्रैक कोर्ट ये केस किया था कि सेशन कोर्ट इसको टाइम बाउंड जस्टिस की तरह सुनेगी, फास्ट ट्रैक की तरह सुनेगी, तो उसमें भी 60 डेज लगे और ये मैटर डिसाइड हो गया। लेकिन वही हमारी अपीलेंट कोर्ट, हाई कोर्ट, इसको मैटर को लास्ट 6 ईयर से सुन रहा है। तो क्या टाइम बाउंड फास्ट ट्रैक सिर्फ ट्रायल कोर्ट पर ये एप्लीकेबल है? क्या जो कोर्ट इस चीज का डायरेक्शन दे रही हैं कि आप कितने टाइम में केस को डिसाइड करोगे, सेशंस कोर्ट को, वो अपने ऊपर खुद क्यों एप्लीकेबल नहीं है उनके ऊपर? और इसीलिए एक और इसमें चीज है कि हाई कोर्ट का जो जजमेंट है उसमें इन्होंने क्लियर कट ये बात को मेंशन किया है कि चूंकि ये अपील अभी लॉन्ग चलनी है, पेंडेंसी है, अभी इसकी पेंडिंग पड़ा हुआ है इस केस में कोर्ट में, तब तक इनको हम ये रिलीफ देते हैं कि इसको सस्पेंड कर देते हैं। तो प्ली क्या ली गई है कि इसको हम तब तक के लिए सस्पेंड करते हैं जब तक ये यहां से डिस्पोज ऑफ नहीं होता है। तो सबसे बड़ा क्वेश्चन ये है कि ये जो डिले का ग्राउंड है, कि डिले से ये पेटिशन सुनी जा रही है, वो उसी डिले का ग्राउंड जो कि कोर्ट की नेग्लिजेंसी से डिले हो रहा है मैटर, उसी को इसलिए ग्राउंड बनाया गया कि हमने सेंटेंस को सस्पेंड कर दिया है जब तक ये डिस्पोज ऑफ नहीं हो जाती है। तो अभी तो मेरिट में तो ये मैटर देखिए ऑलरेडी ट्रायल सेशन में इनको लाइफ इम्प्रिजनमेंट से कन्विक्टेड किया जा चुका है। हाई कोर्ट भी अगर इसको प्रॉपरली इंटरप्रिटेट करती है तो डेफिनेटली रेप केसेस में जो कि पोक्सो एक्ट लगा हुआ है, तो डेफिनेटली इनका जो सेंटेंस है उसको सस्पेंड नहीं किया जाना चाहिए था, क्योंकि ये कन्विक्टेड थे। और उसके बाद अभी जब ये सुप्रीम कोर्ट में गया तो सुप्रीम कोर्ट में ये मैटर हाई कोर्ट की अपील नहीं गई है, ये सिर्फ बेल का जो इनका सस्पेंशन का ग्राउंड है उसको स्टे किया गया है। अभी ये पूरा मैटर हाई कोर्ट में ही सुना जाना है देविका जी।
राइट, एब्सोल्युटली। जैसे कि आपने कहा, बहुत लंबा लीगल बैटल है। योगिता भयान हैज आल्सो जॉइंड अस एंड शी इज वर्किंग क्लोजली विद द विक्टिम। योगिता, आई वांट टू अंडरस्टैंड फ्रॉम यू, what do you think led the court to really even give this order? in the first place? And are we now satisfied with what the Supreme Court has said today?
Yes. First of all, to answer your first question, that definitely there were a lot of lacunas and a lot of loopholes in High Court. Why did they give such a berserk order? And there were a lot of issues. It was some kind of a loose end from the side of CBI for sure, investigation officer, secondly, third from the lawyers representing the victim. I think there was some kind of a connivance, I would say. Something definitely was fishy about it, and all of them put together led to that kind of a stupid judgment. And definitely we can't let go the judiciary's wisdom here, that they gave such an order that it was very self-evidently explanatory, uh, uh, very brutal in terms of that the language itself said a lot of things which were even could be understood by a normal person. Now we have ray of hope. It's like a one step victory, as lawyers will tell you better, but it is a clear cut indication that Supreme Court is aligned to us, and it is willing, it is inclined, as they also mentioned in the hearing, that inclined to give justice to this daughter. And they were inclined towards listening to the victim and her side, and they have given interim relief to us in terms of that after 1 month, even if the convicted criminal wants to kind of appeal, then he has those 4 weeks to work on it. And he has given the victim also, if she wants to kind of put her side of the side, because this was CBI versus, the CBI is a thing today. So however, we really saw that light of the day, and such a big relief after fighting on streets and taking this fight on. I think it's a big relief for us.
Okay, I want to bring in Brinda Dige as well into the conversation. Brinda, I want to understand from you then, when we talk about justice and the larger picture of justice served, you're looking at gravity of the offense. A minor was raped by this man and he's convicted of those charges. You're looking at the power that he wields in general in society, in the areas in which they were operating, and you're also looking at the fact that he is serving a completely separate sentence for the custodial death of the victim's father in this case. When you put all of these circumstances and you put this context together, does it make sense then for the courts to bring in an interpretation based on some sort of a very small sentences and the fine print here?
The court has every right to interpret in the best interest of the law and the case before it. Now, for instance, if you go back to the beginning of this case as to how this fellow asks, the court says the threat perception is not strong enough to keep this convict. He's a convict. It's not even that he's on trial or anything. To keep the convict in jail. So my first question is, what were we lords doing this many years, listening to the various arguments of what all happened to this lady? A minor, raped, gang raped, threatened, intimidated, father murdered, uncle murdered, aunts are surviving, mother is surviving, and then still not allowed to go and attend court. And all this happened while this rapist convict was not in that place, not in Unnao, not wherever she was. How did it happen? It happened by this convict's father, brother, then all his goons and his thugs. How can the court say it does not have that strong perception that she is going to be threatened and intimidated? So I want to find out, is there any application of mind by people who listen to the arguments made by the prosecutor and the defense? Because we are told continuously that this is a sub judice case, nobody should question. But these are people who are sarkari naukars, paid for by the taxpayers, And so you and I have every right to question them, because they are accountable for every work every day that they do. Then they have taken up a procedural, was he a public office, in public office, or was he not in public office? Like Seema madam said, forgetting that the definition is so clear, put over there long time ago. So you will ignore that definition because you are high court judges, and you will reinterpret the whole thing to say on that particular day was he a public officer. What does that show? You are not respecting the letter of the law, neither the spirit of the law. Should not procedural, whatever lapses are there, to be looked at the due process that was followed or not? This is a case where there is political abuse of power and institutional failure. Why should both of these be the burden of the survivor? Why should this be the burden of the complainant? Why are the system and its functionaries not on trial along with this convict? They should be on trial. Why are we not questioning? Why are we not holding them accountable? We are going into small phrases. We are going into the, procedural, whatever is the lapse that the CBI has put at that point of time. Public office, okay, to increase the sentence, fine. Yeah. On what basis does the court say that this person is not a public office? So he has already served 7 years. So no longer we will suspend it. And did the judges even give a little bit of thought to say, when we interpret it to this, for it to mean that we are setting a dangerous precedent? Hundreds of rapists, convicts, and murderers who are in jail now are going to be asking for similar suspensions. Is that what we are asking for when the government is talking about Beti Bachao? Political patronage given to rapists and murderers. You're expecting, okay, this particular survivor had somebody like Yogita to support her, and so they have gone all the way to the Supreme Court, fighting it bravely, courageously, protesting on the street and fighting over there. Can you imagine the hundreds of other survivors who are still fighting these cases and don't have the means and the wherewithal to go all the way up to High Court or Supreme Court? Is that what these people are setting a precedent in mother of democracies 78 years down the line?
Okay, I want to bring it on.
Colonial judiciary must continue like that. There should be no judicial reforms, and we should not hold them accountable. Is that not shameless?
Okay, so on that note, I want to bring in Taira Hassan, because Taira Hassan, my next question really was going to be about the setting of precedents here. As Brinda Dige was also pointing out, in this particular case, yes, the victim as well as the people who are supporting her have said that there is some glimmer of hope that has come in as far as the Supreme Court judgment today is concerned. But when we talk about the vast number of cases that are pending before the courts, when the High Court does give an interpretation, which, like I've mentioned, yes, they have the right to do so, but it's based on fine print, that interpretation. What sort of a precedent are we setting as far as justice in cases of heinous crimes against women are concerned?
Lots of the cases are pending, no doubt, but we are discussing today a case of Unnao rape survivor. First, I salute her. She is a very brave girl. She took head on to such a powerful man in that locality, because I had visited the place when 2017 this heinous crime had taken place. So I can say that she is a very strong girl, and she has witnessed murder of father, uncle, and in accident, her aunt and lawyer, so everything she has seen it. In spite of this, she is so strong. And other thing I would like to say is Supreme Court, this time again stood with the women, with the survivor. The Supreme Court stood, otherwise this man, Sengar, he would have come out of the jail. Don't you think he would have not influenced the entire case or threatened the family? They were scared, that they were under the fear because he is a powerful man. And the second thing that we must appreciate, that the highest court of the land broadly interpreted the definition of public servant. That is one very important thing also has been today done in the highest court of the land. And now it is going to strengthen the deterrence. We must see, we can't say that only few people were with the Sengar. You know, women, I was so shocked.
Yes.
They stood with the Sengar.